Okay, so in this lecture we're looking at psychiatric harm and the court's approach to it. So in White, it was basically said that you can claim for psychiatric harm as a result of a tort, so it's basically your personal injury, if it is medically recognised. So there's a series of cases which can help you see whether or not it's a medically recognised illness. An example is White. It established that PTSD is medically recognised. McLaughlin and O'Brien showed that organic depression and change in personality is recognised, and Vernon shows pathological grief disorder is recognised. If you're wondering about a certain illness, you can look and see what cases you can find and what courts have decided about them. This idea of medically recognised can usually be supported by a doctor. So if you can find a doctor to support that this is medically recognised, the courts will support that decision. So in Alcock, they established different categories for claimants. So first category is where they suffer psychiatric injury as a result of being physically injured by the defendant's negligence. The second is where they're put in physical danger, but they only suffer psychiatric harm. So say you're in a car crash, nothing actually happens to you, no broken bones, no scratches, however, you have PTSD from that car crash. That will fall into this category. And then the third category is where the claimants aren't in any danger themselves, but they witness death or injury to a person who they have a very close relationship with. The first two are categorized as primary claimants, and the third is categorized as secondary. So the duty owed to a primary victim is quite simple because they are in that position. There's nothing to question whether or not they would be affected by it. However, in DeLay and White, it was held that they must reasonably hold this fear. So it would not make sense if the reasonable person in that situation wouldn't have experienced that kind of fear and that level of it. So in Chadwick, it suggested that there was a rescuer. They weren't actually physically harmed themselves, however they were obviously going through witnessing all these things, and the courts held that rescuers do not have to be in physical danger to be a primary victim. And lastly, we can look at Monk. So here there was a foreman. He was comforting two people who had been trapped on a broken platform, and he said that he felt responsible for what had happened and tried to claim as a primary victim under this. It was held that it would be unreasonable for such a person to hold such a belief. When it comes to secondary victims, there's quite a lot more to satisfy. So you need proximity to the primary victim, essentially. So things like parent and child, these would satisfy that quite easily. Whereas with siblings, so you may think that siblings are quite close, you love your sister or brother with all your heart. However, that's not the case for every single sibling relationship. In those kind of cases, you have to prove that proximity. And in Alcock, it says that you basically need a close tie of love and affection. It's quite a high threshold. So there's 4 requirements here and 4 factors to consider. So there need to be reasonable foreseeability, and the nature between the primary and secondary victim has to be established. There has to be proximity to the accident or the immediate aftermath. There has to be proximity in time and space to the events causing the harm. And lastly, you require proximity of perception. So, looking at foreseeability and the nature of relationship. In Boar Hill, there was a car accident a motorcycle accident, a road accident involving a stranger. The claimant went over to the window and looked at it, and then they suffered harm. It was held that it's not reasonable that a person of normal fortitude would suffer this level of shock. Again, you can see that this was because they went out of their way to go and witness the accident and they had no actual relationship to the person involved, the primary victim. In McFarlane, there was this man, he witnessed his co-workers in a horrific accident. However, the courts held that he was a mere bystander. It wasn't a close enough relationship that they were his co-workers. In White, it says that there is still a possibility for a bystander to claim if the event is particularly horrific. And again, lastly, in Alcock, it talks about this close tie of love and affection. That's looking at the nature of the relationship. You have to see how close they are. So, for example, if you have a problem question and there's siblings trying to claim, you have to look and see if there's anything in the problem question to suggest if they're very close, because otherwise that closeness isn't presumed. So if there's something where they see each other regularly, they have a phone call where one says I love you, you can use those things to support this requirement for love and affection. We then need proximity to the accident or the immediate aftermath. This comes from McLaughlin and O'Brien. It basically says you have to witness one or the other. And even I think both would satisfy clearly. So in McLaughlin, she went to the hospital. She was told one of her children is dead. She could hear the other one in pain. She could see the other one suffering. She could see her husband covered in blood. It was as though she arrived to the scene of the accident. It's quite a high threshold. And in Essex County Council, it was held that this immediate aftermath, it has to be assessed on a fact-by-fact case. We can then look at proximity in time and space. So in Hambrook, she was dropping her kids off to school. She only took them partially down the road. At some point, they turn in separate directions, and she sees a lorry railing off, headed into the direction which her children are. So she can't actually see her children. However, she's close enough, and she genuinely feared for their safety. This satisfies that proximity. We then look at proximity of perception. So in Alcock, it basically spoke about requiring sudden shock. So in Liverpool Women's Hospital NHS Foundation Trust, there was a negligent operation. The mother suffered for weeks, and her son and husband were with her while she was going through all this. Here it was held that although all the other criteria had been met, this suffering went on for a prolonged period of time. The shock was not sudden. So it basically shows that the event has to be exceptional, sudden, and horrifying. Here it's a very interesting case in Medway NHS Foundation Trust. There was a baby born with cerebral palsy. This had been avoidable had their care been proper, had there not been any negligence, and the mother hadn't seen her baby for 12 hours. The courts held that 12-hour period is long enough to prepare yourself for something like this, and so she couldn't be suffering from shock. She couldn't meet that requirement. However, the lawyers were quite clever, and they said that she was a primary victim. This was happening while the baby was still inside her. They were one entity. The baby was not its own person yet. And this allowed her to claim as a primary victim. And it's a lot easier to claim as a primary victim because you don't have this extra requirement to satisfy. You don't need to show shock. And this allowed her case to succeed, as she completely got to avoid that requirement. It's quite a recent case. If you want, I'd advise reading the judgment or any summaries on it. And it's a good case to use in problem questions to try and twist whether or not it's a primary or a secondary victim.